Hello, hello, it's me again, the snarky juror. This is Monday morning, day 5 of Florida versus Ashley Benefield in the murder of homicide, I should say, of Douglas Benefield. Hope you enjoyed your weekend. I did for the most part. I also came to a realization. I was trying to figure out all the things that the prosecutor was accusing Ashley of during her cross-examination on Friday. Well, how do you know this? You weren't there. How do you know this? Somebody was whispering in her ear, like the eldest daughter of Doug. My opinion of her has changed with the snide, sly, sicky smiles that she keeps coming up with. What's the word? Jupiter's delight? Jupiter. Is that right? That's not quite it. But they're duplicitous. Somebody who's being duplicitous gives that certain smile. So that's where I can't go there again. That was the most horrific, horrendous, malicious, venomous cross I have ever heard. Ever. And I hope the jury was just as offended as I was. So let's go see what's happening now. If I can remember what buttons to push. So I did that. So I need to bring up this one. Move myself into the corner. Get it off of pause. Day 5 is coming in. That's what we're waiting for. The court had a late start due to one of the jurors had car trouble. So the juror came in late and the judge was having computer problems. And that finally got resolved.
All right, you all can have a seat. Welcome back, everybody. Good morning. I don't know who had car trouble, but I hope everything worked out and you've had time to kind of calm down from that. So we're going to get started. As when we left on Friday, the state was presenting its, the defense was presenting its case. I do need to ask you though before we get started, because we just had a couple of days off. Did anybody discuss the case amongst yourselves in any way? Did anybody discuss the case with anyone outside of this jury? Did anyone do any research or watch any coverage at all?
Does that include a witness who is still can be recalled, posting a bunch of stuff on Instagram? Duper's delight.
About the people, places, things, or legal topics we've heard anything about? No, sir. All right, everybody says no. Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Bruce Ferris.
Oh, good. I don't know if he's going to be considered an expert, but he should be able to talk about domestic violence. Because he never said he was battered woman's. I can't. I was trying to check to see. Yes, I'm in the corner. And we go back to this one, and I can fast forward. Here he is.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do. Thank you. Morning, Judge.
Morning, sir. My name is Judge White. I'm going to be presiding over this case. Just have a seat, make yourself comfortable in that chair. Get yourself about 12 to 15 inches from that microphone. It's pointed straight up, but it does adjust down, left, right, up, down, whatever you need. And if you just speak directly, a loud, clear voice into the microphone, it should pick up everything.
I will.
Good morning.
Good morning.
Will you tell us your full name and spell your last name, please?
Bruce Eric Ferris, last name Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
And how long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
Yes. Been to a lot of training seminars and certifications and various conferences. In my curriculum vitae, I'll call it a CV, my resume. There's about 100 items listed of trainings that I've been to over the years.
For what specific field?
In domestic violence and mental health and trauma to children and trauma in general. And I could go on, but that's the general focus of all my work.
Let's talk about your work experience for a moment.
Oh, okay.
Tell us about it, please.
So as a counselor now, my day is spent seeing individual clients. I specialize, like I mentioned, in domestic violence victimization, both men and women. I also see generalized mental health issues and typical things that a counselor would do, but I have a focus on domestic violence and family problems. I also counsel adolescent boys, most of which are going through the foster care system or adoption or divorce of their parents, etc.
All right, and what position did you hold prior to that?
I was a police officer in Gainesville, Florida for 20 years. I graduated the police academy in 1993, got sworn in 94, and I retired in 2013. The last 10 years of that career, I was a detective, uniquely running. I was a lead detective of what's called the Domestic Violence Unit of the Investigations Bureau at the Gainesville Police Department. Over the course of that time, when I retired, I looked back and did a little search, and I had arrested or filed charges or got warrants on 500 different abusers over those years.
That's a lot.
Mr. Ferris, give us an idea of your professional credentials. Likely.
Sure. I'm licensed with the state of Florida, like I mentioned, as an LMHC or licensed mental health counselor. I have to keep up with education, et cetera, keep my license active. I'm certified as a Batters Intervention Program facilitator. In case anyone doesn't know it, Batters Intervention, which I'll refer to as BIP, is a 6-month class given to abusers who are found guilty or on probation or could be part of their injunction order. And it's a curriculum based upon the Duluth Power and Control Wheel. And it's a psychosexual type, not sexual. It's a type of therapy that involves some counseling and some ownership and learning. And also was a certified police officer, I mentioned. I also have certification as a domestic violence danger assessment and level of danger scoring system developed by Jackie Campbell out of John Hopkins University. And I also have a certification as adoption competency training, mental health for mental health professionals out of Rutgers University. I'll stop there.
Mr. Ferris. And briefly, have you been the recipient of various awards and recognition?
Yeah, I have.
Give us a brief idea.
Okay. The Alachua County Board of Commissioners had nominated me to Governor DeSantis to be part of the Children's Trust Fund of Alachua County. I received the 31st Annual Martha Varnes Award for outstanding achievement in prevention of domestic violence against women. I had recognition for valuable contributions in what's called crisis intervention team. I train officers how to de-escalate confrontations with citizens. I did receive the 2010 Distinguished Victim Service Award for recognition of outstanding contributions to crime victims for National Crime Victims Week by State Attorney General Pam Bondi awarded that to me, and Governor Scott at the time was there for the presentation.
Mr. Ferris,
I'll stop there. There's a few more.
have you been recognized as an expert on domestic violence in various courts of the state of Florida before?
I have.
Approximately how many?
So I've been involved in 60 some cases as either consultant or expert witness. 50 of those I've been recognized by the judiciary as an expert in domestic violence, mental health, batter's intervention, effects of DV on children.
All right, and when you say you've appeared before approximately 60 times as an expert witness, was it for any particular side in a dispute? That is to say, for example, in a criminal case, was it always for the prosecution, always for the defense?
But both. I worked for the state attorney's office and worked for defense. And a majority of my cases have been in civil court, though I have worked in criminal court also.
Would you, Mr. Ferris, tell the ladies and gentlemen of the jury what another definition of domestic violence is?
Well, so there's the criminal statutes of domestic violence, which are typically, we all know it's battery, ag battery, assault, ag assault, false imprisonment, sexual abuse, et cetera, person crimes involving a family or household member against each other. And that has another definition, that's spouses or family members living together, or it could be a couple that had a child together and have never lived together. Doesn't include, let's say, cousins who've never lived together and aren't intimate in any way. But through my experience, I've realized that there's a greater, that's umbrella, and that has to do with power and control. The abuser needs to control their victim. Now, they'll use the criminal things, hitting, et cetera, all those things, but in a greater sense, there's also this, I referenced it earlier, the Duluth Power and Control Wheel that DCF's accepted for the BIP class. I'd like to explain the power and control wheel, if that's okay.
In fact, with the court's permission, we could perhaps have the screen come down and the lights dim. Mr. Ferris, you have a laser pointer in front of you. The little star in red will provide you with
Okay.
dot.
Judge Mack, stand here and pay attention to the mic as I talk.
Any objection?
Okay. So as I mentioned, there's the criminal definition.
Was
And
there a question? Objection. Was there a question?
Go ahead with the question.
Yes. What is it that's on the
Right.
screen?
so what
Mr. Ferris?
okay, so
Mr. Ferris,
yes, sir,
would you please tell us what is on the screen?
I will. So this is what's referred to as the Duluth Power and Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power and control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating your partner, again, to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do illegal things.
Now, I have a couple of questions I'd like to ask you about that wheel that you
Sure.
demonstrated for us. Is this something that you created?
No, this was created by, up in Duluth, Minnesota, there was a domestic violence advocacy group and also researchers, and they looked through police reports, they interviewed victims of domestic violence who come through the shelter, and through a period of time, they developed these 8 items and created the power and control wheel. This wheel is used around the country and actually internationally. Like I said, it's the base curriculum for the Batteries and Prevention Program class I talked about, and it's taught quite readily all across America and by use by domestic violence shelters, etc.
How long has this wheel, if you will, been in existence?
Yeah, probably, I'm guessing 30 years or so. Could be a little more.
Are there any agencies within the state of Florida that predicate their decisions
Yeah.
upon the Duluth Power Wheel?
Yeah, the DCF accepted the power and control wheel for the curriculum for the BIP class.
That's the Florida Department of Children's and Family.
Families, they were the ones who were controlling the BIP class when it started up. Also, a lot of federal money, domestic, against women act, things like that have always promoted the power and control wheel, and also, giving out grants and education money.
Are the majority of abusers male or female?
Majority are male, but there's certainly a percentage that are female. I'd say it's at least 2/3 male at the least. And I, in my practice, I have male victims.
And what about on the other end, the victims of domestic violence? What's the percentage of males and female?
So again, there's some different statistics. Somewhere between 2/3 and 3/4 are men, and
Are men as victims of domestic violence?
2/3 to 3/4 abusers. So that on the other side of that, they're 1/3 to 25% male victims. And I just got a male victim this past week.
Okay, so
Okay, I'm done.
I want to make sure we're clear on this.
Sure.
You've told us that the percentage of abusers that are male is approximately 2/3, is that
At least
correct?
2/3. There's some statistics to make it actually higher.
Would you tell us, please, what percentage of domestic violence victims are female?
Somewhere between 2/3 to 3/4.
All right. Now, I want to ask you if you would educate us, Mr. Ferris, about whether or not there are common characteristics that abusers share.
Excuse me.
And I certainly can do that, Mr. Teller. Can I make one closing statement about the Duluth wheel? And
Sure.
Power and control. So I think it needs to be said, and maybe I didn't say it, that the whole idea of the use of the wheel is to get compliance by the abuser with their victim. So they're looking to control them, and either they use those criminal, the battery, or they use emotional abuse or intimidation or these different techniques to try to control them. So the victim of domestic violence is placed with wanting to have the least harm to them. So they get into a compliance, I call it an equilibrium type of status mode, where they seek to get along, to go along. They don't want to poke the bear. They don't want, they believe that this is certainly a danger to be involved with this person, their mate, their spouse, etc. So they comply, and they in this compliance mode, and they can certainly appear to society as nothing's going on, but there actually is, and they're afraid to display that because of the retribution that might happen.
All right,
I'll go on from there.
This wheel then is the product, if you will, of the science of domestic violence over the past 30
Right.
years.
And throughout my entire practice, the thousands of people that I've counseled and even the 500s I've arrested, I see this repetitively to be true.
All right. Now, would you please tell us,
Oh, I do. Thank you.
I need you to make sure you keep your voice up so that
Yes,
others
sir.
can hear you. Would you now tell us, Mr. Ferris, whether or not there are common characteristics that abusers share?
They can be anyone from all socio-economic stratas, and that's been my experience also. And I said, like I said earlier, predominance men, but also females.
What's the motivation for their behavior, abusers?
They want to control their partners. I find often an ownership type attitude. They want to control them.
How do they treat generally pets in the household?
Pets. So statistics have shown that abusers abuse pets well above average, more than average citizens would. And so I have two theories about that. One is that they're missing some empathy, or they tend to see things as objects. And so,
Object to
Sustained.
non-responsive.
okay. Can I explain why they abuse pets?
Yes.
So if a pet belong to the female or their partner, the victim,
Judge, I'm going to object.
Can you approach, please?
And it begins. Remember, he knocked out the pet? Doug knocked their dog unconscious. I don't know if it was one hit or more, but he knocked the dog out. I have a feeling they're going to be objecting a lot throughout this, because it's going to be pointing the finger right at Doug.
Mr. Ferris, would you describe for us what the term coercive control means in a domestic violence
Sure.
relationship?
So coercive control, acts of aggression, assault, threats and harm, punish, frighten the victims. And that fits in with creating fear, and it fits in with this whole continuum of power and control, a pattern that is developed to control the victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And
All right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
definitely not. Oftentimes, the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever is the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often, when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family,
Why?
because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we've all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And
What
if
is
I'm
the victim trying to accomplish by engaging in the appeasement behavior?
not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again create a type of stasis or minimum amount of aggression. So they don't want to again poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante, we'll speak.
Objection. I have the same objection as at the bench.
I'll overrule on this one.
So yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child, even though it's detrimental to themselves.
A couple of questions about abusers, if I may. How do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern? Excuse me. Is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
I can say a very high percentage, well, I don't know, over 90% I'd estimate of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone. It's one of the 8 categories is minimizing, denying, and blaming, and it's all a technique. Like she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury Mr. Ferris, is there a particular time in these relationships when violence is most likely against the victim?
Yes, very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser, and if the abuser is there, there's a high fatality rate, high incident of danger to them. I've been trained in this in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
Sustain.
All right.
Guess you went too far, Field.
I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions
Certainly.
involving the hypothetical abuser and a hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. Do you want to approach?
Yes.
Oh, jeez. They went over this before. He knew he was going to ask him hypotheticals. I think I'm in the wrong profession right now. Would you rather he come out and say, Doug did this to Ashley? Is that typical?
Hypotheticals, and I'd like you to tell us.
Oh, good. He won.
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim. Cruelty to pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps. Placing a tracker on the victim's car, an illegal tracker. Throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating, declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats if the victim leaves, more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only absolutely, but those are checklist points right off the Duluth Power and Control wheel and right off my experience. They're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical. And tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing, would that be consistent with a victim of domestic violence?
Without a doubt, these are again techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So yes.
Lastly, one other factor I neglected to mention: would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely. And it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident.
Judge, I'm going to object to non-responsive.
Overruled.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
My final question, as it relates in general to domestic violence: assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the earlier acts of abuse?
Without a doubt. I've got clients who tell me about
Sustained.
Yeah, just
so
academically.
yes, definitely they don't forget the abuse that's occurred to them, trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Farrell.
State, Cross.
Thank you, Judge.
This should be interesting.
Good morning, Mr. Ferris.
Good morning.
Mr.
Mr.
I want to ask you give you some examples and ask you if this is consistent with a victim mentality.
Sure.
Minimizing the abuse.
Yeah.
Now you're asking me if the victim would minimize?
Yes. Like what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame.
Yes.
Yes,
Making excuses for him
Yes.
definitely.
or her, I guess, but not reporting the abuse.
Yes.
Right.
Dropping charges if they were
Yeah.
filed.
Yep.
Not standing up for themselves.
Yes.
Yes.
And not leaving.
Yes.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the pie sections each. if
Sure.
you could.
I bet she so wants this over. I know I would.
Sorry, Judge. Well, she's fixing it, and I know you're familiar. And do you have a copy in
I
front
do.
of you? I do
want-
too.
I went
do
right
too.
in front of me.
Okay. And so I want to talk first about the use of intimidation. Would you agree that if somebody This says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic
Yes.
if it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse.
Mhm.
Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship?
Could you restate the
Yes.
question?
So if in this wheel,
Right.
hypothetically, when I'm talking just about using economic abuse,
Right.
would you agree? Would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically?
Mhm.
No financial dependence on
Mhm.
the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
Okay. And for isolation, would you agree that if
So she's only a little bit abused, not fully abused, because she could live on her own for a while. Jeez.
it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think, living on her own with family, and having some periods of no contact for over a year, and then being back in contact, but living separately, and having her own cell phone, having her own car, having her own home. Would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor. for my scenario.
Then isolation component may not be part of that, component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thank you. Using the children.
Mhm.
If the hypothetical victim had
Uh-huh.
custody of the child and attempted to terminate parental rights,
Mhm.
and the hypothetical abuser had to seek court intervention to get the child,
Right.
would that be a factor in your consideration of whether children were being used? If she had sole control of the child.
So you're asking me if I could just reframe that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty. I'm just asking if that would apply. We've talked about how these
Right.
things apply.
It may not apply. It would not apply. But I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing
Okay.
it. I'm just asking hypothetical
Okay.
questions. How about the using a male privilege?
Mhm.
If that hypothetical abuser was not having any control over her big decisions, or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles. In fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay. Can you elaborate?
Yeah, the men's roles. And when you say purchasing things, I would want to look into what is that a concept of what the role is. I'm the man. I purchase things. I control things for you. I decide what to get, et cetera. So that could be a male privilege issue.
Okay, and I understand that, and that was a poor fact scenario in mine. I think it kind of goes with the economic abuse. And what I should have asked is, if she's asking for, can you stop and get me boxes, or can you stop and get me
Mhm.
tape, or can you stop and get me something else? And he is, yes, of course, and he does it. That's what I'm talking about, not him telling her what she may have.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not.
No.
Okay. And so that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
How about minimizing, denying, and blaming? What you said that was present in 90% of the cases.
Quite a bit, yes.
Right.
Mhm.
I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong. I lost control. I shouldn't have done those things, and never says it was your fault you did those things. Would you then feel like that's not minimizing, denying, and blaming?
No, I wouldn't agree with that,
Okay.
because it could be that part of the strategy of minimizing could be that I'm sorry I didn't do it. That could just be minimizing.
I'm sorry no, not I didn't do it. I'm sorry I did it.
Right.
That's part of
That's
minimizing?
still, yes.
Well, certainly not denying or blaming, right?
I would need more definitive
I guess
facts.
I need an explanation on if somebody takes responsibility for accusations against them, how
Right.
that is minimizing.
It's the honeymoon phase.
To say, yes, you are correct, and I am sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be the opposite?
Yes,
That person
it could
is
be.
taking credit, is taking responsibility for their actions.
Right. Certainly doesn't deny that it happened. That's for sure.
Right.
Okay.
And no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors on this wheel,
Right.
and whether or not, if somebody, under my hypothetical, admits to responsibility for the accused abuse and apologizes for
Mhm.
that, whether or not you would consider that denying and blaming.
I would need more information on the relationship in the scenario to decide that.
Is there a scenario? Okay.
You're cherry picking.
Would you, how about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no displaying weapons. I'm sorry. I'm sorry. I'm looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
Well, you gave me a discrete list, but emotional abuse also includes name calling,
Okay.
putting someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no,
Yeah.
it may not.
Yeah, I can't help you with that. I'm not asking the questions.
Oh, I was asking you one. If
I
there was a
know I'm
scenario.
not. You are.
Okay. Would you take into account, based on, with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario, she does not live with him. She's actually in another relationship, potentially engaged to a new man.
Okay.
She tells him that she does not want to be with him,
Okay.
and she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of their relationship.
I guess, so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's uh, an emotional abuse or a physical abuse, but it's not a pattern or behavior. It doesn't go on over a period of time in an attempt to control someone. So, if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence. But that's it. He doesn't, she's not appeasing, she's not put an emotion, the whole power control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't.
Sure it did.
Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse? The parties are living apart. They're independently, I keep saying independently wealthy. That's not what I mean. Independent, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship.
Mhm.
Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
Yes.
with no allegations of
Yes.
no allegations of emotional abuse in years,
Yeah.
it's your opinion that not good enough. They're still on this power
Well,
control wheel.
all I can speak from my critical learning and studying this, and also my practice. And I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
Nothing further, Your Honor.
Can this witness be released?
Yes, sir.
Yes.
Sir, you are released from your subpoena. You're free to go.
Thank you for all your help.
Next witness.
All right, Mr. Taylor, call your next witness.
Gina Torsia, Your Honor.
Judge, I think we're going to have to approach. Thank you.
Okay.
Why are they going to have to approach?
I do.
Actually, as she's sitting down, attorneys come back one more time. Hello, ma'am.
morning, Your Honor. How are you?
Good. Go ahead and have a seat. My name is Judge White. I'm presiding over this case. Just make yourself comfortable in that chair. You want to be about 12 to 15 inches from that microphone. You can adjust it up, down, left, right, however you need. And if you just speak in a loud, clear voice, we should hear you just fine.
Yes, Your Honor.
He's probably done this before.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gina Torcia, Torchia.
Ms. Portia, did you at one time work for an attorney by the name of Stephanie Murphy?
Yes, sir.
Back in June of 2018, would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torsia, what I've marked as Defendant's Exhibit number 25. And ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay, and is it a true and accurate copy of your email to him and Detective Gillum's response?
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Overruled.
All right, now,
Defendant Exhibit 25 will be received.
Wow. That's at
Ms.
least three
Torsia,
overruled.
did you on this day send Detective Gillum a copy of the South Carolina Domestic Violence Restraining Order?
No, because we were not aware of one.
Okay. Does he send you a copy of the order?
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us, Ms. Torsia, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.?
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Ma'am, can you slow down just a little bit?
Oh, I'm so
Thank
sorry. I'm a fast reader.
Okay. well,
Sorry
just
about
slow
that.
down a little bit for us.
Evelyn Wood School, huh?
Where do you want me?
You're good.
Okay.
6 months of the date of the hearing.
Which was May, November, which was May, November 3rd.
Ms.
N-
Torsia,
Yes.
I'm sorry. Would you start over, please?
Yes, sir. Gina, I noticed something that you both need to be aware of, unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be placed for 6 months of the day of the hearing, which was May, November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, it's not something I would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay, we can agree that SAO would be state attorney.
Yes, sir.
So lastly, Ms. Torsia, this is Detective Gillum telling you that the order was in effect, the stay away order,
Objection.
as of November 3rd, 2017, correct?
Objection.
Sustained.
He can't say it
This
again.
is Detective Gillum explaining to you.
Objection asked and answered. She read the email.
Sustained.
Just a moment, Your Honor.
Asked and answered. She read the email. I'll just see how many times they get redundant or try to. So the restraining order from South Carolina wasn't
Let me
that.
ask you what I've marked as defendants exhibit 26.
Can I see it, please? Can we approach this?
They're going to do this to every single thing that the defense tries to put on. They're pains in the butts. My little hack isn't working. Why not? I don't know why not. It was working before. There it is. Keep shooting them down, Taylor. Right.
So, Ms. Torsia, let me pass this to you. I want to see if this refreshes your recollection as to whether or not you sent a copy of the South Carolina order to Detective Gill.
Yes, sir. Yes, this is the order.
Yeah, without referring to it, my question is only, did you in fact, now that your recollection has been refreshed, send a copy of the order to Detective Gill?
Yes, sir.
And then he responds to you a couple hours later with the email that
With-
was introduced.
Yes, and there's
Okay,
also
no
an
further questions. Thank you, Ms. Torsia.
Any cross?
Can you finish your answer, please?
yes. There's also a predicament where Detective Gillum, there was no order entered in to the clerk system in Charleston, and there was no order entered into the Charleston Sheriff's Office. So he had no bounds to make an arrest just based on this when it wasn't entered.
Sustained.
Ask to
further questions.
disregard, Your Honor.
Members of the jury, testimony regarding an opinion's witness about violation of criminal law is inappropriate, and you should disregard those last comments.
No
Anything
further
else?
questions. Thank you.
That's sufficient. Thank you, Judge.
Redirect?
No.
Can the witness be released?
Yes.
Yes.
Thank you, Your Honor.
Thank you, ma'am. You're released from your subpoena.
Would you like to? Thank you.
Mr. Taylor?
Your Honor, I wonder if we could publish.
Nope.
That's my phone you hear ringing in the background. I have an answering machine, so. Excuse me. What we're waiting on. I missed them saying who the next witness was. God, jeez. These people. You're shooting all kinds of holes into your prosecution's theory. Not even Flex Seal's going to seal that back up.
I think it's a great time for our mid-morning break. So I'm going to send you out. Be about 10 minutes or so. Feel free to use the facilities. You can use your phones if you need to send or receive text messages, emails, phone calls, anything like that. Please don't begin any sort of deliberations or discussions amongst yourselves about the case. Don't discuss the case with anybody outside the jury. And don't do any research on the people, places, things, or legal topics we've heard anything about. And 10 minutes, 15 minutes, because I also want to give everybody else in here a break as well. So, see you back in a few minutes. All right, so the issue is a police report that I haven't seen, but it's my understanding what it says is that Ms. Benefield went physically to the telephone reporting unit of the Manatee County Sheriff's Office. I'm going to summarize, you can correct me. With
You had it right so far. But
all right, so this isn't marked. Is it, did you seek to admit it as an exhibit or just testimony?
No, just testimony.
All right, so you expect the testimony would be from a deputy with the sheriff's office that Miss Benefield went to the telephone reporting unit on December 6, 2019.
Phone call.
That Miss Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past. That she has observed him driving behind her on multiple occasions, which concerns her. And she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed.
He's trying to figure out how else would he know.
All right, any objection?
the objection, Judge, is that anything contained in this report, which the nature of this report, according to it, is information. But anything contained in this report is hearsay other than that Ms. Benefield physically appeared at TRU on December 6th, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if he remembers.
Oh, yeah. It's irrelevant, even though she's meant.
Opponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense. I do not plan to ask the deputy to read it. I'm going to ask him if he took a report from Ms. Benefield what the date was and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
And that's hearsay in the state's opinion, Judge, because any.
No, it's not
self-serving
hearsay.
It's actually hearsay within hearsay,
No, it's
I
not.
think.
No.
That if he wrote something and asking him what he wrote in a report about somebody else told him, but it's at least one level.
No.
All right, thank you both very much. The purported reason for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed. That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle. And my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
So that's already in. And I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about them. And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence. So at this point, this is not marked. What was the, who was the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay. Scott Lindsay.
Lindsay.
It's on the top
Scott,
of the report.
Scott Lindsay, I'm sorry. Lindsey.
So, I mean, you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling it for, so, yeah.
All right, I do want to give you all a break, though. I know we started at 9. It's about 10:30. I think it's reasonable to go ahead and take a break. So why don't you guys take 10 minutes?
Thank you, Judge.
Court be in recess for 10 minutes.
Okay. Well, I appreciated the clarification and why he wasn't going to let it in. basically stating it's already in that that Doug actually he himself admitted to it, even though they never.
Maybe run and jog in place, warm up a little. So we've got the defense going to call their next witness, but before we do that, I did want to ask that anybody begin deliberations amongst yourself, speak with anybody outside of the jury about the case, or do any research on those topics we've talked about. Everybody says no. Mr. Taylor, call your next witness, please.
Thank you. Vincent Vizzacaro.
Vincent.
Case of court, please, right hand.
Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Is that a Italian name?
Hello, sir. As the deputy said, just make yourself comfortable in that chair. My name is Judge White. I'm going to be presiding over the case. You can adjust that microphone up, down, left, right as you need. Stay about 12 to 15 inches away. Speak in a loud, clear voice. It'll pick up everything.
Sounds good.
Good morning.
Morning.
Would you tell us your full name and spell your last name for us, please?
Vincent Vizzacaro, Vizzacaro.
All right, Mr. Vizzacaro, I'd like you to try to keep your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
And where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Do you have any particular specialty?
Residential homes in Lakewood Ranch.
How long have you been doing that?
About 8 years now.
Excuse me.
I want to ask you whether or not back in 2018, you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a home.
Hearsay.
I'll overrule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Lakewood Ranch.
All right. And back in 2018, Mr. Vizzacaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizzacaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach Jeff?
Yes.
Okay. Don't want to hear that either, huh? I have no idea where this is going. Perhaps Doug was trying to get away with something or trying to set up something or something. That's further clarification. Not.
Get you back out here as soon as I can. Don't forget, could leave, close your. All right, members of the jury, I do need a few minutes to resolve a legal issue. That's my responsibility. So if you could close your notes, leave them there on your chair, and I'm going to excuse you back into the jury room for a couple of minutes. I will get you back out here as soon as I can. Don't begin deliberations. Don't talk with anybody outside the jury, and no research on any of the issues. Thank you.
So what's the problem, prosecutor? Ain't looking too good for
All right,
you,
y'all can have a
is
seat.
it?
Mr. Vizzacaro, What I'm going to do is at this moment, I need to do some research and speak with the attorneys.
Okay.
So I'm going to excuse you to the hallway. There's a thing called the rule of sequestration that has been requested by both parties.
Mhm.
And that means that you cannot discuss your testimony or the questions asked of you with anyone else. You can't discuss other witnesses' testimony or what questions they were asked or what testimony they gave while here in court. Or do any research on the case, watch it, or anything else.
Understood.
All right, we'll call you back as soon as we can.
Okay, thank you.
Thank you.
I guess the emails would be considered hearsay. But that gentleman can verify. The emails can also say, I said this. I received
All right, I'm just going to ask before I start doing my research, do you have any cases that you want me to know about right now?
No, Your Honor.
All right,
I'm-
so I'm sorry, go ahead.
We're traveling under the words in the statute, specifically 9803 6.
Understood. All right, so I'm thinking I need about 10 minutes or so. So we're going to take a 10-minute recess, maybe 15-minute recess. I want to look this up as well because I want to find a case that gives me some direction.
Sure.
Right, yes, sir. Thank you.
Is it just me, or is he paranoid about?
Of course, that means you can too when we go back on the record.
Yes.
Is he paranoid about ruling something that can be overturned, or
Honor specifically, so
is this normal? I have no idea.
Printing something.
All right, the objection is hearsay. Any other objections?
Judge, also, I would like to make a relevance argument that the fact that he's going back and forth in this email about a specific property, there's no relevance to it.
It shows state of mind. Yeah? Is that a good one?
All right, proponent, go ahead, sir.
well, I think it's admissible, one as a business record, which we've already qualified. Business records traditionally contain hearsay. And under the statute, Your Honor, specifically subsection C, we got this email from the state. However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection according to the business records exception. We also believe that it shows Doug Benefield's state of mind, that he was in the process of buying a home directly behind Ashley Benefield's home during the time period when the South Carolina injunction was in full force and effect.
Ooh. He wasn't paying any attention to that injunction.
All right, anything else, sir?
No, sir.
State?
Judge, I found a case I would like to Thomas v. State, 993 Southern 2nd, 105 from 2008. It is specifically addressing an email that was put in as a business record. I didn't have long to read this, but it was an email that was sent to an apartment complex manager of some sort. And it appears as though it was not qualifying as a business record. And additionally, the hearsay within the email was not admissible. There is a yellow flag, and I'm trying to look at it now.
Wow. So the state knew this, gave him estate info, and he gave it back stating he'll be using it, but the state never said nothing more. So the state can dump stuff onto the defense without specifying anything, but the defense can't do the same thing. But man, this is blatant disregard. Blatant disregard for anything. It's proof. State of mind. I sure hope he lets it in. It's just further evidence of him not willing to let go. That's really interesting. That's called a nugget.
All right. Did you review Thomas v. State, Mr. Taylor?
Yes, sir.
All right. Do you want to make any argument on it?
No, sir.
So Thomas v. State is helpful. It's 993 Southern 2nd 105 First DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record, and I seem to, I don't see where they actually found and held that the email was a business record, which was my original question, but ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that although hearsay may exist within exhibits that fall within an exception, such as business records, those hearsay statements must still qualify under a separate exception to the hearsay rule. And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzacaro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Van Sant v. State.
But that was an employee.
Vanzant, 372 Southern 2nd 502, Florida 1st DCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. but the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is his state of mind. It clearly shows Mr. Benefield, let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence. And here is Mr. Benefield, Judge White, negotiating with the realtor to buy the house directly behind the home where Ashley Benefield lives. And he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice. That corroborates your defense.
Do you want to be heard on 90.8033, an existing mental, emotional, or physical condition?
Judge, his emotional, mental state, that still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
Sure it is. He has an injunction against him. He shouldn't be trying to do this. He's supposed to be staying away from her. Renting, buying, doesn't matter. He's closing in on her again. It's harassment.
All right, as I've said before,
Don't be a wimp, Judge.
are you going to establish the location of the home through Visicaro,
Yes, sir.
where it was
Yes, sir.
in relation to the house where Miss Benefield lived?
Yes, sir.
And then are you going to then just argue during closing? I would assume.
Yes.
All right, so there's going to be no more witnesses. This is the end of this road to establish
Yes. This is just
witness-wise.
This is an isolated act of DV. Yes.
All right.
Judge, if she didn't actually know about this, then I don't know that it's relevant.
Well, and that's what I was thinking because, hold on, it's not an act of violence though,
Right.
or threat, but
Intimidation.
under 9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, design, when it's offered to prove the declarant's state of mind, emotion, or physical sensation at the time or any other time, or prove or explain acts of subsequent conduct of the declarant.
Then, Judge, I would just ask that this witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email. Just, were you helping Doug Benefield and were you looking at a certain house?
I think that would obviate some of the evidentiary concerns I have that you asked if he was assisting him in finding a location. Did you find one? Where was that location at that you were talking about putting an offer on?
Indeed, and if the court rules against the admissibility of the email, that would be my intention. On behalf of Ms. Benefield, though, I would like to present the best defense that I can. And I think that the email clearly is something the jurors can have, read, see. It's tangible. It has the same kind of impact, Judge, that the prior inconsistent statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be kept out, I would like to admit it.
Thank you both very much. I will allow the admission of Defendants Exhibit 27
All right.
under 90.803(6) for the Realtors portion and 98.03(3) for the Benefield portion. With the understanding that, again, this is a relatively collateral matter.
In and out, Judge.
All right, can you bring the witness back in, Mr. Vizzacaro?
I feel hopeful. I feel hopeful. The defense is allowed to show the other side of Mr. Perfect and Wonderful. He looks like a realtor.
All right, welcome back, sir. Just take your spot back there in that chair. We're going to get the jury back in and begin your testimony.
Sounds good. Thank you.
Bring him in.
I think I should be standing.
Outside the jury about the case or do any research? Everybody says no. Mr. Taylor, you may resume your direct examination.
Thank you, Judge White. Mr. Vizzacaro, when we last broke, you told us you were a realtor and that Douglas Benefield had contacted you relative to a house in Lakewood Ranch.
That's correct.
All right, I'm going to pass to you, Mr. Vizzacaro, what I've had marked as defendant's exhibit number 27. That would be the email messages that you referred to before when we were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's exhibit 27 will be received.
Now, Mr. Vizzacaro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you.
And show how close it was to where Ashley was living. I'll betcha that's what he's going to do.
And as luck would have it, we have the pointer. Okay, so this will give you
The beam?
Okay. Would you please show us on that diagram where the house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now, that house, is it directly behind the house in front of it with a red dot on it?
Yes. Yes, it is.
Okay.
And the red dot is where Ashley and her mom live. I mean, that is direct.
Do you know, Mr. Vizzacaro, who was living in the house with the red dot at 11331 White Rock Terrace?
No, I don't.
And do you know whether or not, if I may, you know whether or not you don't know who was living in this house?
No.
This is the house that Mr. Benefield was interested in purchasing.
Correct.
Do you know whether or not Mr. John Sant lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything further.
Doggy needs to go out. Be right back. Okay, then. I let the doggy out and wrestled with 2 hoses while I was at it. Back to some more fun stuff. Is that the one I want? Yep. I'm in the corner. Make this big eye. And where are we? Where are we objecting again?
And ask you if you can identify it.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in Exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport News Circle,
On
excuse me.
behalf of Ms. Benefield, Your Honor, move to introduce that as defendant Exhibit 28.
objection.
Received.
That's all. Thank you very much, Mr. Fisicalo.
You can
Gotcha.
cross.
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just
That's right.
grab it real quick. And for the record, this is State's Exhibit 27. And it appears as though
No, that's defense.
you're speaking with Mr. Benefield about potentially this house coming up, or the price being lowered on this house, correct?
That's correct, yes.
All right. So you were contacting Mr. Benefield about
I reached out to him about that.
Okay. And he actually said he may just want to rent. Isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashley first.
That was a comment that was later in the conversation, yes.
Okay. And if I could show you State's Exhibit 27, it's very small type at the top. So you might be able to.
That's why.
For the record, defense exhibit.
I'm sorry, Defense Exhibit 27.
Okay, thank you for clarifying that.
Does he say there that he needs to speak with Ashley
That's
first?
It
hearsay.
appears that way, yes.
Okay.
Yeah.
Thank you. No further questions.
You redirect?
Nope.
Can the witness be released?
Yes, sir.
Ma'am?
Yes.
All right, sir, you're released from your subpoena. You're free to go.
Thank you.
Mr. Taylor, can you state, defense, can you approach real quick?
Why?
Defense would call, Your Honor, Dr. Jason Quintel.
Dr. Jason, something. Until.
Yes.
I think we already saw him, didn't we? During like a voir dire type thing.
Hello, doctor, welcome back.
Hi there, thank you.
As you may recall, my name is Judge White. I'm presiding over the case. Same rules as last time. Just make yourself comfortable. Adjust that microphone as you need. Speak in a loud, clear voice.
Yeah, he's the one that they were just making, and you wouldn't believe.
Good afternoon, Dr. Kinsey.
Hi there.
Welcome back.
Thank you.
As a result of the counseling sessions that you had with Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. Opinion testimony.
Are we going to do this again?
Can you go ahead and approach?
Counseling. I can't find it in my notes. No surprise there. Oh, that's right. Quintal. I'll go back a smidge. Certified social worker. All right. Now let's advance. I think I went too fast. Let's go. Let's go. Let's go. The state is like, how dare you put on a defense? What we said is what it should be and nothing more. That's the impression I get. How dare you put on a defense? How dare you argue with what we said? We can insinuate all we want, because after all, the victim isn't here. We have to speak for him. You can't speak for him, but we can. And there's probably legal reasons for that, but it still pisses me off. I don't give a flying leap.
Okay, Dr. Quintal, so a couple of questions about your practice.
Yes, sir.
I think you told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And
Well
as
said.
part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms, and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
I don't do specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
No,
All right.
that's not what he was asking.
Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection, qualifications.
Sustained.
Did you counsel Douglas Benefield?
I did, yes. Both
In-
Ashley and Doug.
All right. And in counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes, both when they came in as a couple and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay. And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Okay. Now, in making those observations
Pulling
and
teeth.
questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection, foundation.
Would you approach, please?
Oh, come on. We know you want your golden boy to be perfect, but guess what? He wasn't. He was an asshole. Am I allowed to say that? All right. He was an abuser. How's that?
Deviation, Dr. Quintel. A brief deviation, Dr. Quintel. Tell us what degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been practicing as a psychologist?
I got my master's in 98 and started working in the public school system. So since 98, 2006, I started a private practice.
And since you've been in private practice, Dr. Quintel, can you give us an idea of the number of patients that you've seen in counseling?
Thousands.
And your specialty in counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
Okay. And when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally, the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory So emotionally, the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally, they're transported back to that awful moment, right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment. So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
And in that process, do you typically employ listening to patients?
Yes,
Do you typically employ making suggestions to patients?
I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome.
Okay. Now,
So more instead of a suggestion, it's more of kind of a mutual outcome.
all right, and you went through this process with both Doug and Ashley Benefield.
I did, yes.
All right. Your Honor, I would tender Dr. Quintel as an expert in the field of psychology.
Do you want to voir dire the witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
All right.
Jury goes away again.
You do most of your work now in trauma resolution, correct?
I do, yes.
Okay. And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
I don't look at diagnoses with people. I look at people because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or, bipolar? I would say I work with people, not the disorder.
Okay. So when you're dealing with, for instance, Doug and Ashley Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to get at is there's a difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay. And so your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma, and there was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Okay. Thank you. Any further questions?
You may resume your question.
So in treating people, not the disorder, you still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Quintel as an expert.
And I
You
would
wanna be heard?
object. as to
Same
the issue.
objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you.
All right.
So, Dr.
What's wrong
Quintel,
with the judge?
all right, we're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male? Do you recall?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintel, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise.
Overruled.
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right. And did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
Interesting.
Did there come a time when you
I'm sorry, I can't
inquired
hear
of Doug
him.
why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child. And I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection, if I may.
Sounds like he was hell bent to me. But then, who am I?
Thank you.
Does that refresh your recollection, Dr. Quintel, as to Doug's perception of letting Ashley get away from him?
Looks like he forgot a few things.
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintel, did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as
Objection, hearsay.
Sustained.
did you reach any conclusions, Dr. Quintel, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevance.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child, and I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed, with Emerson and the child outside in the bar, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all you're on.
Cross.
So what was Ashley doing all this?
So you mentioned that it bothered you, or at least you noticed when he didn't go out to see the child. How long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child.
Yes, I did.
Okay. And I believe, and correct me if I'm wrong, in your direct examination, you said you met with Ashley Benefield alone 5 times.
Yes, ma'am.
And you met with Doug Benefield alone twice.
Yes, ma'am.
And you met with them together twice.
Yes, ma'am.
So the majority of the time you met with Ashley Benefield. Over half of the times you met with her.
To do trauma resolution. Yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
Okay. So it was not solely based on things that you were observing in Doug Benefield.
No, ma'am.
Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State. All right, sir, you're released from your subpoena. Thank you very much. Here you go.
Thank you.
All right. I can get out of this.
Can we publish the couple of exhibits that we put in through listed as a column? And then we'll lunch break for lunch. I don't think that's.
Oh, that's not.
Yeah.
Oh, you have 27?
One photograph was already in,
One.
and then one we added together with the.
Yes, so members of the jury, we're going to pass these out and publish them. I'm not rushing you, but I'm going to talk while we're doing that. I think at this point, it's a good time for our lunch break. It's about 10 minutes after 12. So take your time. I want you to look through all of this, look through these exhibits, and then I'll excuse you.
26 and 27.
Those 27 and 28, and they'll be marked on them. There's a little sticker on each. Which should say 27, 28, and I think the other one is Defense Exhibit 1.
would imagine by now she's tired of being called a victim. But unfortunately, that's the facts. She was a victim. She's now a survivor. And that'll be part of her healing process, is to see herself as a survivor.
We at 1:30. Should give you plenty of time if you want to go somewhere, if you just want to walk downtown. Be in the jury assembly room at 1:30, and we'll get you back up here as soon as we can to get started for the afternoon. Remember the admonishments: don't talk amongst yourselves with anyone outside of the jury, or do any research on the people, places, things, the legal topics we've heard anything about. Thank you.
Well, give it a couple minutes here, make sure they're not going to consider anything. I guess this lady here is a very close friend of Ashley.
All right, y'all can have a seat. I would assume, before I let you all go, that the request for an exhibit list from the defense of the items that they expect to introduce has been provided,
Yes.
and certainly a list of witnesses that are expected to be called.
Yes.
I didn't get a copy of that. If it's been amended from the witness list that I received, it looks like it was filed June 21st of 2024. So I'll just mark, but who do we have on tap for this afternoon?
So
I don't need to know the order, but just who?
We have Jason Alexander, Michael Haig, Haag, Dr.
Hold
Emma
on one
Lou,
second. I'm sorry. I got it. My list is, okay. Michael Haig.
Michael Haig, Dr. Emma Lou,
All right.
and Warren Justin.
Warren.
Justin, the lead homicide detective.
That's 4 if I counted right. For the
All right. None of these, have all these folks been deposed?
Yes.
All right. Are there any objections or anything I need to hear before we get a jury in and get them seated and make them sit there for 5 or 10 minutes while I hear arguments at the bench? I would much, much rather have the objection made. Let's talk about it, and then let's call the jury in so it's a little bit smoother.
With Detective Warren, I may have objections, but I don't know what's going to be asked. So without asking what they're going to ask, I don't think we can have that conversation. And additionally, if Detective Gillum is set to testify, I would have similar objections.
You didn't say that name.
No, they've been keeping him here, so.
Okay. You think just 1, 2, 3, 4 witnesses are going to take us the whole afternoon?
Yes, I think there's a reasonably good chance we rest today.
Okay. Oh, is this the bulk of what you're calling at this point?
Yes, sir.
Okay. Well, that would be fine, because then we could do a preliminary charge instruction this evening. Then you guys can decide if you want to do any rebuttal. Okay.
So the one request I do have, Your Honor, is for Mike Haig, who's our ballistics expert.
Mike.
We need
Mike
Haig.
Haig. Yes.
H-A-A-G.
Okay.
We need the HDMI cable to run to the witness stand, so he can plug his laptop.
To where? Here? I don't understand.
Yes. Projected. Yeah. So it'll be up on the projector.
So he's going to use his laptop to project here.
His testimony, yes, sir.
Well, I know this is the one we used. don't know, Deputy, does that stretch to here?
We'll inquire and we'll check it out.
Oh, you know what? IT has got to come and fix my computer anyway. So can you tell them that we also need that a witness this afternoon is going to have to run to that?
Yes, sir.
Thank you so much. And then that'll take care of both, because my goblins, it's just, you know how it goes.
Okay,
All right.
thank you, Judge.
I guess the only other question the state would have is there were other witnesses that were held by the defense. If these are the remainder of their witnesses, are those witnesses being released? Because they're asking the state for this.
We don't know what they're presenting in
Yeah.
rebuttal.
Okay.
They're holding on to them just in case they need it for rebuttal. That makes sense. The state just, I don't know who that gentleman is. I don't know a lot of things. All righty, looks like we're heading to the seal. Yes. No, sorry. It seemed appropriate at the time. Okay. It's time to eat, I guess. Blood sugar's dropped. I'm getting slap happy. Slap happy. All right. There was a lot. We heard from the licensed mental health counselor who did that Duluth Power and Control Wheel. Someone who worked for Stephanie Murphy, Gina Torchia. That stated that the restraining order was effective the day of the hearing, not later on the 27th. And it stated it right in the order. Then we heard from the real estate guy. Now, this was ominous to me. Even though he had that order against him from South Carolina to stay away from her, he's up there making arrangements to purchase and or rent the house that was directly behind Ashley. Directly behind. That is so creepy and so typical of people like this who have obsession. It's an obsession. It's like, oh, no, you don't. And he didn't care what any kind of judge said. He was sneaking around behind the scenes. And then the counseling social worker who just testified stated, even though a lot of the information came from Ashley, but he recognized the validity of what she was saying, or he would not have defined Doug as domineering, controlling, very built, the alpha male type. And Doug's perception of himself was godly, and it was over the top. Why remain in the relationship? Not going to let her get away from me. That says it all. The state is driving me crazy because this should not have come to this point. This should not have come to trial. Unfortunately, it was a justified homicide in my mind. She feared for her life. She defended herself. Unfortunately, he died because she was defending herself. She perceived herself in such danger that she grabbed a weapon and she shot. This should not have gone this far. Let's end it for now. We'll be back for the afternoon. So until we come back for the afternoon, you know what's coming. You know what's coming. Until we come back, take care and God bless.